Hello everyone, this is Lahama Mazumdar, Assistant Professor, School of Law and Justice, Adamas University, Kolkata. In this video, I will be speaking about the doctrine of distinctiveness under the trademark law. The doctrine of distinctiveness is an important concept in the law governing trademarks and service mark. A trademark may be eligible for registration or is registrable if it performs the essential trademark function of being distinctive and having a distinctive character. When understanding the concept of what essentially could qualify as a trademark, the Trademark Act of 1999 defines trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and may include the shape of good, their packaging, and combination of colors. To qualify as a trademark, it should be a mark that can be represented graphically, and the mark should be distinctive. That is, it should enable its consumer to differentiate the goods of the trader from that of its competitors in the marketplace. A trademark as a mark would include a device, a brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or a combination of color or any combination thereof. The above definition essentially emphasizes on the communicative ability of a mark. Trademark is justified as it enables those engaged in trade and the public more generally to discover quickly and cheaply which signs third parties have already claimed. The trademark system requires the registrar to depict accurate information about the mark. As I said in the earlier slide, the distinctiveness is one of the important concepts of the law governing trademark, and a trademark will be eligible for registration and may be eligible for registration if it is performing the essential function of distinctiveness. Registrability could be understood from the contonym with inherently distinctive mark at one end, generic and descriptive mark with no distinctive character at the other end, and suggestive and arbitrary marks lying between these 2 points. A trademark is required to be capable of distinguishing the goods or services of one person from those of others. To be distinctive or capable of distinguishing the goods, there may be some inherent qualities or distinguishing characteristics in the marks itself which make it so distinctive or capable of distinguishing the goods of one person from that of others. The concept of trade dress, which includes the overall look and feel of the trademark, is inherently built into the definition of trademark under the Trademark Act. The initial registration of a trademark shall be for a period of 10 years, but may be renewed from time to time for an unlimited period by payment of the renewal fees. Therefore, the term of protection of a trademark can last till perpetuity. Such long-lasting monopoly, like right, requires a trademark to be one that is capable of performing the necessary function of distinguishing the goods or services of one trader from those of others. the function or the capability of distinctiveness of a trademark. This capability may be inherently distinctive to a certain extent or may be acquired by the use of the mark by the consumer from time to time. So essentially there are certain marks which are by its own nature inherently distinctive, which we might term as the arbitrary marks. For example, Apple for laptop, and certain marks are acquired distinctive, which due to their extended usage over a period of time has developed the kind of remembrance in the mind of consumers, and the distinctiveness has developed along the lines. A sign that is not distinctive cannot help the consumers in identifying the goods of their choice. The word apple cannot be registered for actual apple or apple juice, but it is highly distinctive for computers. What it is trying to say is that maybe when we use apple for apple juice, it will not essentially help the consumer understand from which source it comes from, because it is a common resource which is available for all. It is already there in the public domain. So it is not at all distinctive for apple juice because it will not help the consumer identify its source. Inherently it will not. But if somebody uses the word apple to signify computers, it is an inherently distinctive choice, because at one instant nobody will be able to relate the fact that apple as a mark is currently being used for signifying the source of manufacturing of computers. So one of the tests for determining the registrability of a trademark is whether the trademark is distinctive, and when determining distinctive, the test is whether the trademark is distinctive. That test is dependent on understanding of the consumers, or at least the persons to whom the sign is addressed. So the test of distinctiveness is entirely dependent upon the consumers of a particular product. If the sign is not used before registration, then the test is to identify whether it is capable of distinguishing the goods from a particular trade source. A sign is distinctive for the goods to which it is to be applied, when it is recognized by those to whom it is addressed as identifying goods from a particular trade source, or is capable of being so recognized. The distinctiveness criteria is not an absolute or unchangeable factor, rather it is purely circumstantial. In the famous case of Abercrombie and Fitch versus Hunting World, which is the United States decision by the Second Circuit, this particular case is important because it had established the particular test of distinctiveness. It had established the spectrum of distinctiveness, trademark distinctiveness in the United States, which had broken trademarks into classes which are afforded and accorded different degrees of protection. Courts often speak trademark falling along the lines of spectrum of distinctiveness as also called the Abercrombie specification. Now let me discuss the facts of the case of Abercrombie and Fitch versus Hunting World, which gave us the doctrine of distinctiveness. So Abercrombie and Fitch were using the particular trademark Safari for different products, different clothing lines that it sold in its sporting goods store. For many years, Abercrombie and Fitch were using the mark Safari on articles of clothing sold by it for its sporting goods. Abercrombie and Fitch filed an action for trademark infringement against Hunting World which according to Abercrombie & Fitch had engaged in retail marketing of sporting apparel again, some identified by the use of safari alone or by expressions such as mini safari or safari land. So understand this, that both Hunting World and Abercrombie & Fitch were using the word safari, the word mark safari, mini safari, right, safari land, similar to safari by Abercrombie & Fitch, for sporting goods, right. So essentially the market that they were using it was for sporting apparels, right, for clothes, the sporting apparels, right, and they were using the trademark safari. Now, on the reply of Hunting World and on an appeal from the judgment, what happened was that all the registrations of Abercrombie & Fitch with regard to safari were cancelled, because it was established that safari was a generic trademark with regard to sporting apparels, right. So here, while this particular decision, the court essentially broke trademark into several classes of distinctiveness according the particular criteria of which kind of a mark or which kind of a word mark would be afforded the highest criteria of protection or the highest category of protection, and which mark will be accorded the lowest category of protection. So here there were 5 particular kind of marks which were essentially classified. First is generic mark. A generic mark does not qualify for protection. If you refer back to the earlier slide, we essentially stated that when we use apple for selling apple juice, right, apple is a trademark for selling apple juice, it is not distinctive, it is a generic mark. So because apple itself signifies apple juice, so it is not eligible for protection. It is the weakest in the market. Second is a descriptive mark. The descriptive mark sometimes qualifies for protection, right, which essentially describes the kind of product that is being sold in the market. Next is a suggestive mark, which to some extent qualifies for protection, and the other two are highly qualified for protection. One is an arbitrary or a fanciful mark. For example, apple, it's a fanciful mark, which apple is essentially what it is, a fruit, but when you use that apple fruit for signifying products like a computer, it is fanciful, it is arbitrary. There is no link between the word and the product that you're selling. So it is extremely powerful with regard to the protection. And another is an invented word. Invented word is afforded the strongest level of protection. For example, Kodak. Kodak for camera, right? Kodak was not there. It's an invented term. You can definitely sell it. So this is the spectrum of distinctiveness from the weakest to the strongest protection, right? The criteria being that the nexus between the mark and the product is inversely proportional to the protection attached, right? The more direct the nexus, like in the case of generic, the lesser the protection, right? The direct the link, the direct the nexus, the lesser the protection. The more arbitrary the link, the more distance, the lesser the nexus between the mark and the product, the more the protection. So the nexus between the mark and the product is determining the kind of protection. The nexus between the mark and the product is inversely proportional to the protection so attached. So now let's understand the specific criteria that were developed in the case of Abercrombie & Fitch versus Hunting World. The first being generic mark. As already stated, generic mark essentially signifies a term that one refers to or has come to be understood as referring to a genus or a class of which the particular product is a specie. They do not warrant protection Because if one seller could trademark a generic name, other sellers would be unable to describe their products and thus would be at a great disadvantage. Ivory would be generic when used to describe a product made from the tusk of elephants. Milk to be the brand to protect milk, or the word hiking boots to brand boots. So these are generic, right? For example, if you use milk to sell boots, it would be arbitrary. But when you use milk to brand the product milk, for example, milk, dairy milk, or any dairy product, if you use milk to sell dairy product, it is generic. You can't use it. It is the term itself is referring to the genus, right, of which the particular product is a specie. So you can't use it. Such words have become public juris or are generic to the particular product, right? It belongs to the public at large, so it cannot be appropriated, or the proprietary rights for that word cannot be given to one person. So that monopoly is not affordable for the society at large. So that is why in case of generic marks, such kind of protection is not available, right? The next class of protection, like generic being the least, right? The next one in the hierarchy is descriptive mark. So generic is the least, the next is descriptive marks. So descriptive terms or symbols generally identify attributes of the product, such as the purpose, size, color, ingredient, origin, and so forth. Merely descriptive general marks do not qualify for protection. A term is descriptive if it forthwith conveys an immediate idea of the ingredient qualities or the characteristic of the good. For example, Holiday Inn for a particular hotel. So it is not at all distinctive. It is not essentially describing the particular, it is not essentially arbitrary, it is not fanciful, it is descriptive of the idea of going for a holiday. So it is not very descriptive in nature. It lies below in the particular line. Tasty bread. Bread is supposed to be tasty, right? It is one of the qualities, one of the purposes of making a bread, of selling a bread. Right? So it is not descriptive, it is not distinctive for that matter. It is a descriptive mark, so it is not distinctive, right? For example, Dalma for Orissa, it is talking about the origin of that particular product, right? So then when we talk about the origin, when we talk about the color of the product, right? Orange for selling orange, right? For selling oranges, so orange juice for that matter, right? It is a descriptive mark. So it does not qualify for the protection, right? Because it immediately conveys an immediate idea of the ingredients, ingredient qualities, and the characteristics of the good. These kind of marks are only eligible if they acquire a secondary meaning, in the sense that if it acquires distinctiveness after being used for a period of time. For example, surname as trademark, right? If for example, Goenka Institute, right? It is a very landmark institute. It is already there in the market. So when you use the surname as a trademark, it is not inherently distinctive, right? Because Goenka is a surname that is held by multiple people in the society. So why would you give one person the right to use it singularly? It's not possible, right? One person cannot be given the right, right? So now when you use the surname as a trademark, inherently you cannot give the monopoly to one person to use that particular mark, right? What essentially matters is whether the person has, or whether the particular product has, or whether the particular mark in relation to the source has gotten the kind of distinctiveness by being used for the period of time whereby it creates a special place in the mind of the consumer. If the consumer has reached a place whereby they link the particular mark back to the source, back to the creator of the trademark, back to the producer of the particular trademark, then you can actually accord it protection. So a descriptive mark is not eligible for protection until and unless it helps the particular consumer relate it back to the source because of attainment of a secondary meaning. To acquire a secondary meaning, the public must associate the mark with the manufacturer or the seller rather than the underlying product itself, right? As you can see, a surname is incorporated. It is basically a descriptive mark. It does not qualify for protection until and unless a secondary meaning is attributed to it. For example, McDonald's, Hilton Hills, right? Goenka Institute. Until and unless it acquires a secondary meaning, it does not qualify for protection. So till now we have, according to the Abercrombie spectrum of distinctiveness, we have gone for generic mark, and then we have also read about distinctive marks in terms of descriptive marks. So about generic mark does not qualify for protection. Descriptive marks qualify for protection only when it acquires a secondary meaning. For example, surnames, right? It acquires a distinctiveness only through acquired means, only through acquiring a distinctive meaning through a secondary meaning, right? Whereby the public must associate the mark with the manufacturer or the seller rather than the underlying product itself through repeated usage through the time. The next kind of mark according to the Abercrombie spectrum of distinctiveness is a suggestive mark. A suggestive mark does not essentially describe the product, although an inference must be made about the product must still bear some relationship to the mark. It requires imagination, thought, perception to reach a conclusion as to the nature of the good. For example, when you hear the word pathfinder is essentially saying that, you know, it is something that is at home off-road. So you're trying to reach your path, you're trying to find the way back to your goal or your destination. So it's pathfinder, right? But when you think a lot, when you try to understand what pathfinder essentially means, after giving it the imagination, thought and perception, it is suggestive of the fact that it might be providing you the service of a coaching institute, right? It might coach you to reach your goal. So pathfinder is essentially a trademark of a coaching institute, whereby it shows the path to a student to reach the goal of qualifying for a competitive exam. So then pathfinder is what? It is a suggestive mark, right? It does not describe the product, although an inference may be made about the product. The product must bear some relationship to the mark, right? It bears some relationship to the mark. It is suggestive of the product, but a direct inference cannot be made out of it. Another example is a Roach model. So if you go onto the particular product, right, on your screens over here, if you see, it is Roach model. So it is used to actually catch cockroach, right? So when you look at the trademark Roach model, you will not be able to understand. It is suggestive that, okay, it is a roach motel, so somewhere the cockroaches stay or something. But it is essentially what? It is roach motel is a particular product that is used to catch cockroach. Right? It is used to catch cockroach. So it is suggestive of the kind of product that it is trying to sell. Right? It does not directly describe about the product, but it is definitely bearing an inference, right, about the product, right? Some relationship is there between the mark and the product, but it is not very direct. It is a suggestive mark, right? It is not bearing any direct relationship to the mark. There is no relationship, there is no direct nexus between the product and the mark, but the nexus is suggestive in nature, right? In case of generic mark, the nexus is very direct. In case of descriptive mark, it is describing the origin, the nature, the quality of the product. So the nexus is a little, not very direct, but yes, it is direct, right? So that is another criteria. Now there is a suggestive mark. A suggestive mark is not descriptive about the product, but yes, still an inference may be drawn about the product, right? So it is highly more distinctive in the spectrum from generic and descriptive, right? Highly more distinctive. So it is basically somewhere in the middle with regard to its criteria for achieving a protection. The next criteria, the next particular head under the doctrine of distinctiveness, under the spectrum of distinctiveness, is a arbitrary or a fanciful mark. So marks that are arbitrary and fanciful do not describe or suggest any characteristics of the product. When the meaning of the symbol used in the mark is not inherently related to the product is more likely to be associated with the symbol, ensuring that the consumer recalls the arbitrary association drawn by use of the unrelated symbol for identifying a product. For example, Apple for computers, right? It does not describe or suggest the characteristic of the product. It does not. But when the meaning of the symbol is used in the mark, it is not inherently related. The product is just associated with the symbol, right? So, because it is not directly describing it, right? When Apple is used for apple juice, it is directly describing the product. But when Apple is used for computers, it is not describing the product. So what you would do is you would relate the particular symbol, you would relate the word mark back to the one who is creating the product. So back to the entity who is creating that particular product, right? They have no inherent relationship with the product and are thus understood to be fanciful, right? These are arbitrary marks, right? These are arbitrary marks. That is why Apple for computers is one of the most arbitrary and fanciful mark, because here they are not, the mark is not directly related to the product that is being sold in the market. It is not suggestive of the particular product. It is not descriptive of the particular product. It does not describe or suggest any characteristic of the product, right? It is not inherently related to the product, right? So when the particular mark is not directly inherently related to the product, it is more general that the particular mark will be associated to the particular source, the one who is creating that mark. So it is more general that you would relate it back to the source of the product, right? Because of the arbitrary association. So here the consumer recalls the arbitrary association drawn by the use of the unrelated symbol for identifying a product. These words have no inherent relationship with the product and are thus understood to be fanciful. Now this is the fourth in the criteria of, in the spectrum of distinctiveness. The most distinctive in the spectrum is the invented word, right? The fifth one which has no nexus, like the mark has no nexus with the product, right? Because here the word itself is invented. The word was not there in the public domain. Somebody has created that particular mark. For example, Yamaha for a motorbike. Yamaha was not there. Yamaha, you created that particular mark. So when you create the mark, it is distinctive, right? It is distinctive. It is something which is invented by the particular entity in order to make it more relatable back to the source, right? Because it is a created word. So the consumer base itself never knew that, that the mark could exist because the word is new. So it is very difficult for an invented word to actually make it through the market, because people will not know about it unless and until it makes a point in their mind, right? But it is also highly distinctive in nature. For example, Kodak for camera, right? It is a invented word. So it is the most difficult to establish in the market, but also highly distinctive in the criteria of spectrum of distinctiveness. It is the most highly distinctive mark that can be there. So let's have a little task with regard to how to understand, with regard to trademarks, what is a more distinctive item and what is a less distinctive in the criteria of in the spectrum of distinctiveness. For example, penguin. So if you use the word penguin as a trademark, right? So penguin for a particular shop, right, which specializes in polar species would be descriptive in nature, right? Because it is penguin is relating to polar species, and that is why when a shop is specialized in polar species, it is essentially not so distinctive. It is a descriptive mark. Until and unless it acquires a secondary meaning, it will probably not be capable of being registered as a trademark. It is a suggestive mark for an air conditioning company, because penguin for an air conditioning company is suggestive of the kind of product that it might sell. It is an arbitrary mark. It's a fanciful mark. If it is the name of a book publishing company, right, nobody will be able to relate penguin to a book publishing company. So it is, of course, a fanciful mark. It is high in the spectrum of distinctiveness. It could acquire protection. It is inherently distinctive. And penquel is a coined terminology, right? So it's a coined term, so of course it is highly distinctive in nature. So it is exactly how we see the spectrum of distinctiveness, right? One is not distinctive, one is then again gaining the light in the spectrum of distinctiveness, like penquil being the most distinctive, right? Inherently distinctive. So now what you could see is that, when we talk about distinctiveness, it could be classified under two heads. One is inherent distinctiveness, and the other being acquired distinctiveness. So earlier, before Trademarks Act 1999, we had the Trade and Merchandise Act, Marks Act 1958, whereby India provided for a bifurcation in the registrability of marks depending upon the inherent or the acquired distinctiveness of the mark, where only inherently distinctive marks were registrable under Part A of the register, whereas in the Part B, even if it was not distinctive but was capable of distinguishing the goods from the proprietor, from its goods of the proprietor of the goods, by reason of the use of the mark. So basically, when it acquired the secondary meaning, right, when it had acquired distinctiveness, it would be registered under the Part B, right? The trademark was in fact so adopted to distinguish, or was in fact capable of distinguishing, right? So Part A was for inherently distinctive mark, and Part B was for acquired distinctiveness. For example, surnames, right? Now all of that has been parted ways with. So there is no system of registering Part A or Part B, right? It has all been made into one. The act has adopted that, if there is distinctive character, if the mark is capable of distinguishing, then it is if it is of a distinctive character, it can be registered, right? Section 9 clause 1 of the Trademark Act provided that even if a distinctive trademark may be registered, if before the date of application of registration the mark acquires a distinctive character on account of use or has become a well-known trademark, such restrictive trademark may be registrable owing to the mark having acquired a secondary meaning in the mind of the consumers. So today, even secondary meaning, like even acquired distinctiveness, is considered to be distinctive in nature under the Trademark Act. So here we would end the discussion